not take in the, yes.
Thursday, madam. On Thursday, madam.
Sorry.
On Thursday,
He
madam.
wants Thursday, he is my opinion.
I also filed an reply. That is also not in the record.
Thursday,
Yesterday,
my lord?
Let the item be called.
Yes, yes.
Let's see what is the matter about.
Lord.
Or you want a simple adjournment? Yes.
Simple.
Will not.
No, I want fixed date.
Then let the item be called.
Yes, no.
Lord, I have tried for listing of a case, my lord.
Why?
This is matter pertains to my provincialization of services, my lord. The government, my lord, took time on 6th of my lord, June last year, my lord, to file a counter affidavit. We are asking for 4 weeks time only. The case has not been listed, my lord. May I pray before your lordship to list the case in the next week, any day. After vacation.
Give it after vacation.
Just after on 30th of my lord, October.
Lordship, therefore, listing for motion.
Why? What is the urgency?
Compassionate on Friday.
After vacation. There's no urgency.
Compassionate.
We'll take up after vacation, not now. No, now we have to clear some other matters. Yes,
May I
ma'am.
please, Lordship, I beg to mention the listing in admission column. I have filed stay is there and I have filed for stay vacating. So urgency is there, Lordship. So on 12th.
What is the urgency? What
stay-
has been stated?
State means there was an inquiry being conducted in a private minority institution, Lordship. So it's minority institution, they have the certificate from the Minority Commission of India. So they have that certificate and it's governed by, and as per the Assam government private schools.
I think we'll take up after the vacation. We'll need some.
Little urgency is there because.
No, what
she
is, no, what will happen? What will happen in 15 days? What?
Stay is
What?
there, so.
Understand? Stay. Many people are having stay.
So she has to
So,
be paid.
understand
Salary is being paid. If-
what salary?
Yes, Lordship, salary is
You
being
can
paid.
wait for 15 days. We'll take up immediately after the vacation.
There is an urgency is there, Lordship, on the school authorities, Lordship.
School authorities, what urgency they have?
Because they are paying for, because since stay was there, so they have. to
Understand?
pay-
So you pay for 15 more days. So we'll take up immediately after the vacation. If you're not entitled to pay, we'll pass orders accordingly.
Yes, Lord.
Because we have some very less time. That's why I'm
Understood.
saying. Suppose
Yes,
there
Doctor.
are matters which cannot wait for 15 days, we'll take it up. Not that we won't take up anything. No, you can give them, we'll give a date at the
Listing of a motion matter, Lordship. Urgency is that, Lordship, the challenging the selection of a candidate, Lordship.
Sorry, what is the urgency?
Lordship, urgency is that regarding the selection of a candidate who was selected in the post of superintendent in Netaji Subhash Chandra Bosu Avarshya Vidyalaya at Hailakandi district.
No, that is okay. Now what will, somebody is selected. You want to
Yes,
challenge that selection.
Yes, Lordship.
So why urgency?
Because, Lordship, he has selected instead of his ineligibility, Lordship.
Sorry.
Two person was called for the interview, Lordship. And one is the preferable subject was psychology and MSW. The person selected who has not even hold this degree, Lordship. And even though he has
Person
been
selected do not have the degree.
Yes, Lordship. This
They are not
psychology and
qualified.
MSW,
They are not qualified.
not qualified.
We can pass that order at any time after 1 month also. Rito ko or anto.
It have only that he
No,
will
no. After
get
1
the
month
appointment
also,
and
we
join
can
the
pass the
service.
order that he will not hold the office if he does not have the qualification. Where is the urgency?
This is the only opinion that the appointment will be given and he will join in service.
Okay, we can always reverse the situation. Doesn't mean that you have to approach before something is there.
Selection order on issued on 5th, Lordship.
Sorry, we are having little difficulty.
Friday, Lordship.
Friday for evening. Yes, what is the urgency?
There is no urgency, Lordship.
Then give it, we'll list it immediately after the vacation. Sorry.
And IA Lordship, the correction of the container number, Lordship, inadvertently, wrongly corrected.
Okay, give that one.
Yes, yes.
Give it one. Yes, madam. What is your urgency? What is your, yeah, Mr. Sharma is waiting for a long time. Huh? Yes,
Notice,
Mr.
pray for listing of a matter in admissions column. I understand it may not be as urgent as.
No, because difficulty is we have to hear, we have to pass orders correct online. Time is very
Yes, I
limited.
understand. I'll
So
take
that stage has come.
I'll take back.
So you give the memo, we'll accept it,
Yes.
but as per convenience. Yes,
Okay.
ma'am.
Your Lordship, I'd like to mention for listing. This matter, since long back, this matter not listed. Last
Sorry?
list- Since long back, the matter not list, last list on 14/2/2022.
So if it is not listed for almost 1 year, 8 months,
Yeah.
it can be listed after 1 year, 9 months also, wouldn't make any difference. Give it, but after vacation. Yes.
I think it's an item number 6. That they can be
6.
consent.
Hmm. Adjournment. Adjourn of the, you are there?
Yes. It may only kindly be fixed after, immediately after.
Adjourned on the prayer of Mr. B. Kaushik, Standing Council for Elementary Education, to be listed after the vacation, immediately after the vacation.
All right.
I'd like to mention for listing of the contempt, yes, Lordship. It says that partially complied, but consequential financial benefit.
After the vacation, give it. No.
Item 1 for admission.
That one. Will you hear it today?
As your Lordship.
I think we have to interpret the 2 Supreme Court orders. I mean, not interpret, look what the 2 Supreme Court orders provide for. Take it immediately after vacation. List on immediately after the vacation.
Date will be given.
We'll give a date. What did you find, Mr. Talundar? The later judgment does not change the course of the earlier one.
The vigor is not only 3 acts were
In the later judgment, 3 states on their own, they had promulgated their own legislation.
those were after by the 6.
So that means reading the 2, onus is on the state now. If you want, you can allow. If you don't want, you don't allow. You want to allow or you don't want to allow.
Some sort of
No, here, taking note of the tradition of this state, you want to allow or you don't want to allow?
that is actually not in a regular, in the other states, those 3 states, madam, it was done in a regulated.
No, here also, you bring in what manner you want to regulate it, considering the safety of the animals.
There is no such.
No. If you say that we are unagreeable to even look into this issue, then even if we pass an order, it will be a futile order. Then we'll have to think of hearing in a different manner. But if you feel that, yes, we can also look into the aspect, then maybe taking note of the 2 Supreme Court judgments, we can require the state to take a decision. Because here also, apart from the technicalities of that paragraph 42 and I think 42 of that first judgment, this is a tradition which is in existence. It's not that this is something very recently introduced.
It falls from your lordship. Then
Number one, no, it cannot fall from us. The court does not have the power requiring the state to legislate.
But limited, possibly lordship. Because
Um,
state doesn't have any such cycle.
No. Why don't you take a decision that yes, we want to look into it, or you don't want to look at it at all?
That will also be possibly that to that extent will also be right.
See, on one hand, there is a bar of para 42 of the first Jallikattu judgment. Supreme Court has provided that certain things has to be done in a certain manner. Second one gives the impression that if the state on its own legislates on that subject, courts have nothing to say. And you add to it saying that it is done in a regulated manner.
No, regulated manner, it was done in a regulated manner by those three acts. Those three.
No, those three states, they have introduced it in a regulated manner.
So that was up.
So you also take a decision as to what can be done.
Possibly that will also.
Because this is very difficult to balance this aspect by a
Because in
court of
one
law.
hand, Supreme Court also
Bec-
upheld that.
Because
in
of
paragraph
one
31
hand, it's an admitted position, it's a long tradition. It's not something very recently it started appearing. Maybe initially tradition was different. Now in the enthusiasm, the tradition has been
must have-
deliberately changed to make it more attractive. Say you are saying that you keep the buffaloes hungry. You try to provoke the buffaloes. If you do all these
Listing of
things,
dates and all.
buffaloes will be more excited and the fight will also be more exciting. So people will get more excitement out of it. Maybe you can control those aspects.
What should we indicate possibly?
Because initially, I don't think this provocation and all these things were there.
Those are not there.
Early in the earlier times. Earlier times, possibly it was a and if you have studied the animal nature, without provocation also they'll start a small fight amongst themselves. If the two buffaloes happen to be belonging to two different clans, they can't stand each other when they see it within their own area. So maybe you can think of some more regulated way. And if the fight exceeds beyond their particular brutality, there has to be some intervention somewhere in some manner, and it is for you to do how to intervene it. You can think of putting two nets in between. I think if you want, you can think a little out beyond. What do you say? Because two aspects were required to balance. One, the brutality on the animals. Two, it's a long tradition. So why should a tradition should also be stopped merely because people are now intending to carry out the tradition, the tradition in a more provocative manner.
Which are not there in the earlier.
So the illegality is in the conducting in a provocative manner. May not be on the tradition. The violation that takes place of the law is because of the provocative approach. Maybe you can. Why don't you take a more holistic and broader view on the whole thing?
Possibly, Lordship may indicate those aspects.
Then that will be almost an order from the court side.
No,
The government will be very happy as indicated by the court we are doing this.
direction
So
of-
tomorrow something happens, oh, it is the court who had done it, not us.
Unless-
But
Also, I'll give-
But there is a requirement of the authorities also to take a decision on this thing. You can't remain on one end of the pendulum. If you look carefully, para 42 pertains basically to the brutality that is caused to the animals.
Non-performing.
We have materials before us, as per your own report, that because of the outside provocation, the brutality is enhanced, which makes the whole thing more exciting. So if brutality is the illegality, and it is caused by provocation, possibly
Instead
the
of stopping
illegality
the
can
event,
be related to the provocation. It may not be to the tradition.
They should also come up with some ideas. how to-
No, Madam Chair, we will come up with ideas. Heard MS B. Chaudhary, Learned Counsel for the petitioner, also heard Mr. B.J. Talukdar, Learned Senior Counsel for the respondents. By district petition, the petitioner's assail, where is the impugned order?
Page 35.
35, assails an order dated 13/1/2015 of the officer in charge of Dharampur Police Station, which provides that pursuant to the direction of the Honorable Supreme Court, the President stroke Secretary of Aitijya Mandita Ahadguri Ancholik Mojuz Committee was asked to refrain from conducting the buffalo fight. Mr. B.J. Talukdar, Learned Senior Counsel for the respondents, relies on the pronouncement of the Supreme Court relies upon the pronouncement of the Honorable Supreme Court
In Nagara.
in Animal Welfare Board of India versus A. Nagaraja, reported in 2014 7 STC 547, wherein in paragraph 35, upon interpreting section 3 of the Prevention of Cruelty to Animals Act, what is the name of the full act?
The Prevention of Cruelty to Animals Act, 1960.
1960, it was observed that well-being of the animals means the state of being comfortable, healthy, or happy. And forcing a bull and keeping the same in the waiting area for a number of hours and subjecting it to scorching sun is not for the well-being of the animal. And forcing and pulling bulls by nose ropes into the narrow closed enclosure and subjecting it to all forms of torture, fear, pain, and suffering by forcing it to go to the arena and also overpowering it at the arena by the bull tamers are not for the well-being of the animal. In paragraph 44, it was observed that bulls, therefore, in the view of the Honorable Supreme Court, cannot be performing animals anatomically not designed for that, but are forced to perform by inflicting pain and suffering in total violation of section 3 of the Act of so and so. Mr. B.J. Talukdar, Learned Senior Counsel, relies upon the aforesaid two observations and conclusions of the Honorable Supreme Court to justify the impugned communication by which the petitioners were restrained from indulging in a buffalo fight on the occasion of Magh Bihu. MS B. Chaudhary, Learned Counsel for the petitioner, on the other hand, submits that buffalo fight is a long-drawn tradition which existed in the state of Assam and is particularly performed as a part of the festival of Magh Bihu. In response to the same, the state authorities has produced an inquiry report. Where is that? An inquiry, no, an opinion
From the expert.
rendered by wildlife experts.
His name is Vibhav Kumar Talukdar. Last year.
Namely, Vibhav Kumar Talukdar, who is associated with the NGO Aranyak, which is intricately connected with the protection and welfare of wildlife. Where is that line that somebody?
Second page, in such, third paragraph, my lord, in such human-induced buffalo fights for entertainment in this paragraph.
In the opinion, a view is expressed that human-triggered buffalo bullfights among the domestic buffaloes are totally against the ingrained natural attributes of the buffaloes. And human-induced buffalo fights are mainly organized for the amusement of humans. But the opinion also reflects that buffalo fighting in some parts of India is recognized as a tradition, and there are various superstitions associated with buffalo fighting in India. But what is noticeable is that the opinion also states that in such human-induced buffalo fights for entertainment, the buffaloes are brought into the arena by their respective owners, and the buffaloes are subjected to commotions. Loud instruments like gongs are played in order to agitate the buffaloes. And sometimes they are kept tied up and hungry for days to make them aggressive. And also on many occasions, the buffaloes are forcibly fed local intoxicants for creating anxiety, aggression, and restlessness in the buffaloes. And further, that often in such human-induced fights amongst the buffalo bulls, there are fatalities to the buffaloes. A reading of the afore extracted opinion of the wildlife expert draws the court to draw a parallel to what is provided in paragraph 35 of the judgment of the Honorable Supreme Court in Animal Welfare Board of India, Supra, wherein also it was noticed that forcing the bull and keeping the same in the waiting area for a number of hours and subjecting it to scorching sun is not for the well-being of the animal. And forcing and pulling the bulls by nose ropes into narrow closed enclosures and subjecting it to all forms of torture, fear, pain, and suffering by forcing it to go to the arena and overpowering it at the arena by the bull tamers are not for the well-being. From such point of view, with reference to the opinion of the wildlife expert referred above, if human-induced buffalo fights for entertainment, if in human-induced buffalo fights for entertainment, the buffaloes are brought into the arena by their respective owners, and are subjected to commotions. Loud instruments like gongs are played in order to agitate the buffaloes, and sometimes they are kept tied up and hungry for days to make them aggressive, and also forcibly fed local intoxicants for creating anxiety, aggression, and restlessness, would have to be viewed to be an act imposed on the animals, which would be against their well-being as interpreted by the Supreme Court. But at the same time, MS B. Chaudhary, Land Counsel for Petitioner, on the other hand, refers to a subsequent decision of the Supreme Court rendered in
Animal Welfare Board of India.
rendered in Animal Welfare Board of India and others versus Union of India and others, reported in 2023 SCC Online SC 661. Wherein certain legislations enacted by the states of Kerala, Karnataka, and Tamil Nadu after
Possibly Maharashtra.
and Maharashtra, after the pronouncement of the earlier judgment referred, that is Animal Welfare Board of India, Supra, to provide for bullfighting in those states, when the same petitioner, Animal Welfare Board of India and others, had assailed the constitutionality of the aforesaid legislations enacted by the 4 states.
Three states.
Mr. Talukdar, let us complete the order.
Right.
3, 4 will decide later on. Keep a look. In Animal comma, were assailed by the same Board of India and others. In the later judgment, referred in short as Animal Welfare Board of India 2-2 for India, comma, the Honorable Supreme Court, by its judgment, had upheld the constitutionality of the legislations enacted by the 3 states. Accordingly, it is the submission of MS B. Chaudhary, Land Counsel for the petitioner, that as the subsequent legislations legitimizing the bullfights in the states had been upheld by the Honorable Supreme Court, therefore, there is an implied modification of the provisions of the earlier judgment of the Honorable Supreme Court rendered in Animal Welfare Board -1 kori thoi dia, -1 Supra. Supra nalage -1 kori thoi dia. Kobat eta 1. Accordingly, it is the submission that as there is an implied modifications of the propositions laid down by the Supreme Court in paragraph 35 and 44 of the Animal Welfare Board 1, therefore, the submissions of the state authorities to rely upon the said provisions to justify the impugn communication dated so and so would no longer be acceptable. But Mr. B.J. Talukdar, Learned Senior Counsel for the petitioner, on the other hand, by referring to the complete judgments in Animal Welfare Board 1 and Animal Welfare Board 2, submits that there is neither any express nor any implied modification of the provisions of paragraph 35 and 44 of the propositions laid down in Animal Welfare Board 1. And therefore, it cannot be accepted that the said propositions cannot be relied upon by the state authorities to justify the impaired communication rated so and so. It is also the submission of Mr. B.J. Talukdar, learned Senior Counsel for the state authorities, that the three legislations enacted by the aforesaid three
Tamil
states,
Nadu, Karnataka and Maharashtra.
by the three enacted by the had been upheld in as much as by enacting the legislations, the state authorities had also provided certain provisions therein which would regulate the bullfights. And because of such regulatory provisions in the legislations, the effect of paragraph 35 and 44 of the judgment of the Supreme Court in Animal Welfare Board 1 would be mitigated to a great extent. Taking note of the opinion rendered by the wildlife expert, it is discernible that the well-being of the buffaloes are adversely affected because of certain provocative acts being conducted by the organizers of the buffalo fight, like subjecting the buffaloes to commotions, keeping them tied up and hungry for days to make them aggressive, and also on occasions feeding them with local intoxicants for creating anxiety, etc. But at the same time, it is also an admitted position of the parties, including the petitioner and the respondents, that prevalence of buffalo fights during the Magh Bihu is a long-standing tradition in the state of Assam. When we read the two submissions together, that the buffalo fight is, on one hand, is a long-standing tradition, and on the other hand, the opinion rendered by the wildlife expert that during the buffalo fights, the buffaloes are subjected to certain provocative acts to make them more aggressive, comma. Any illegality committed on the buffaloes, including violation of Section 3 of the Act of Human, as well as the proposition of the Honorable Supreme Court laid down in paragraph 35 and 44 of the Animal Welfare Board 1, would be more relatable to the provocative acts that the organizers may inflict upon the wild animals. In the circumstance, which apparently, as per the submission of the state authorities, may have been taken care by the three legislations that had been enacted by the aforesaid three states. In the circumstance, the respondents in the state of Assam, through the which department? Don't leave it to one OC or one circle officer or somebody like
Respondent number 4 and
that. Who is he?
the officer in charge.
No, we don't leave it on the police and DCs. Somebody in the government.
Principal Secretary Home.
Because it was issued by a police officer. so
It was issued by OC, and we don't want an OC to take this decision.
Yeah, direct the chief secretary.
I think it will be better. The chief secretary to the state of Assam may look into the aspect of the long-standing tradition of buffalo fights being performed in the state of Assam during the Magh Bihu festival, which is a part of the tradition, as well as the resultant well-being of the animals being put to jeopardy because of any provocative acts being inflicted by the organizers. And any view that may be formed, be informed to the court. And any resultant view that may be formed, be informed to the court. And the comment taken note, the chief secretary is required to take a conscious decision on the aspect, and any view that may be formed, be informed to the court.
Keeping this matter pending.
Lordship,
Because we cannot direct, mind you. We don't have the power.
And
We can only say that the law went in this direction, then this had happened, it went in direction, that these are the things to be looked into. You look into it.
Lordship, the Constitution bench had also taken note that in para 42, if I may read, Lordship.
With a second one,
Yes, Lordship.
it is second animal welfare.
Even if we proceed on the basis that the legislature is the best suited branch of the state to determine if a particular animal sport are part of the cultural tradition, if such cultural event or tradition.
No,
offends
where are
the
you
law,
reading?
Para 42,
Is it same as the
mine is Manupatra.
Manupatra? Always they have the habit of changing the paragraph numbers.
The
SCC contains the original paragraphs put in by the Supreme Court. Manupatra, they have the habit of changing it. What's your first word in your para 42? How does the line paragraph begin?
That was the 5 questions referred
No.
and replied.
Please read the first few words of para 42 of your copy.
Para 40, Roman 2, Jallikattu is a type of bovine sport and we are satisfied on the basis of the materials disclosed.
Just a minute. Jallikattu is a type of book. In this respect, the Chief Secretary may also take note of the provisions of the Honorable Supreme Court in paragraph 44 brackets Roman 2 of the judgment rendered in Animal Welfare Board India 2 by referring to the paragraphs as appears in the paragraph numbering of SCC online. Again, we look into something else. Or else, why didn't you take this copy and send it along with it?
copy of the
Because Manupatra will have different page number. That Supreme today, they have another paragraph number of their own. Instead of quoting it, I'm just referring. So if the Chief Secretary takes up another source, that paragraph 42 will be different from what we are referring. Or you make a photo and set it right. List again also, so after 1 month. After 1 month? A copy of this order be made available to Mr. Assisting Mr. BJ Talde. Mehdi. Mr. P.K. Mehdi, Land Council, assisting Mr. BJ Talde.
Item 2.
In this matter, my lord, I am under the instruction to take assistance of Mr. Senior Counsel, Mr. U.K. Nair.
Yes, please.
Today he is not available. Some difficulty. He is out of station. Any date, my lord, convenient?
As we have heard the matter, we want to do it early.
Lordship, my lord.
Thursday?
Thursday, my
Thursday,
lord.
Pari?
I
Only thing, I think Madam Ghosh's submission is page 40 or something that you relied upon, 44 or 40 or something like that.
yes.
Hmm.
Yes, page 40, Lordship.
40. She says that whatever pay scale is provided in page 40 would be applicable. Okay.
Yeah.
We want your submission only whether that is applicable or something different is applicable.
My lord.
We don't want your calculation.
My lord.
Your calculation you may have done in many different methods. We can't understand those also. Only thing whether page 40 is applicable, read with page 33, if I'm not wrong.
Yes, Lordship. Page 33.
33. So page 40 and page 33 read together shows that the basic pay of this category of employees will be the basic pay plus grade pay plus PSP. So that if that is the basic pay and taking that to be the basic pay, when you refer to page 40, whichever entry suits them. This is their submission. Basic pay, there should not be any difficulty because page 33 is very clear that PSP will be added to the basic pay. Only thing, whether the scale of pay provided in page 40 will be applicable or it will not be applicable.
Yes.
If it is applicable, you have to go by that. If it is not applicable, then you tell us what is applicable. Then you will show us your calculation that this is our calculation.
I got it.
Then I can understand.
Yes.
Otherwise, if you say this is my calculation, how can I say whether it is right or it is wrong?
True.
And they are very specific. They say that this is applicable, page 40 is applicable. So you either say page 40 yes or no. If it is no, then what else is applicable? Show us that what else is applicable.
Yes.
I love if, my humble submission, if finance and accounts officer to call for before this court, he may explain the calculation.
No, we don't want.
And,
That person will create some more confusion. First, tell us if page 40 scale of pay is not applicable, then what is applicable? Next question we will ask you, why not page 40? Why the one you are referring? If you satisfy both the answers, we'll follow you.
I got it.
And one, on the last occasion, one peculiar situation had arisen after hearing that after the pay revision, this man is will get something lesser. That concept is very difficult to accept. There cannot be any pay revision that after revision, one man will get less than what he was originally getting. It can never be.
No, it can never. And that in fact had not happened.
And if it has happened, the man will say, don't give me the revised pay, give me the original unrevised pay. Revision of pay is only to increase, it's never to decrease.
No, never.
So within this controls, please.
Yes, I'll much of it.
This constraints are 3, 4.
3 and 4.
Yeah.
because part had
Sorry.
humble breath.
here, 4 may be taken first. because
এইটো এইটো হাৰ্ডিন পাৰ্ট কৰি থৈ দিয়ক আছে আগতে আছে নেকি ইয়েছ মেম
my lord, in this case, my lord, 4 may be taken first, my lord. This is the
আইটেম
first
4
item 4. This is the base case, my lord. After subsequently, my lord, the 3 was filed.
তৰুণ চন্দ্ৰ বৰ্মন that
Yes.
one তৰুণ চন্দ্ৰ বৰ্মন you appear for the petitioner
I will pay for the petition in item 3.
and you are in item 4 why do you discriminate between Saikia and Mr. Tamuli
No, my lord, this is only.
and
the
you want to
reason-
hear Mr. Saikia first
No, no, my lord, think that will be.
ahead of Mr. Tamuli
That will be easier, my lord, so that is why. Case is same, my lord, on the basis of the same selection, they both, my lord, challenge my selection as a principal, as a headmaster of the school. Same selection. And that too, my lord, in fact, my lord, whatever they are challenging, they are, my lord, not considered in the selection process. That is a different selection.
Mr. Mohanto I think he has the right to start
My lord.
the respondent cannot begin and preempt his case we can yes sir.
My lord, in this case, my lord, the petitioner report also has challenged the selection and appointment of the private respondent.
Where is the advertisement? First, let us see. For the post of some headmaster.
My lord, advertisement also will find.
Headmaster of what? Dharampur Gyano Dayani High School, Nalbari. That one.
Page 22.
Page 22. That's it. This is a common advertisement
My lord,
for the entire district.
my lord.
Okay.
Petitioner kindly note the date, 25/8/2007. At that point of time, my lord, turn 3 route was in force.
What is the last date of submission?
December 2017. my lord.
No, this is to the NBC Nalbari with reference to your poster. In connection, you are to ascertain the existing, this is only vacant. Where is the advertisement?
Well, this is the initiation of the selection process.
Understand?
There is no such advertisement.
Why did you make an application? Pursuant to which document?
This document.
This document does not call for, this document asks the inspector of school to do
Yes,
something.
The inspector of schools will forward the name. The director.
Okay.
Made the selection.
Pursuant to this one, inspector forwarded the names. Means you don't apply.
My lord.
What is the rules? Governed by 18 rules.
3 rules.
Huh?
2003 rules. my lord.
3 rules.
17
Which page? 3 rules. Do you have it in this book or I take the older book?
263. my lord.
This book itself, 263. Three? 379.
Rule 14. my lord.
Promotion, no? On the basis of in the school.
Procedure base, my lord, 380. Rule 15. my lord.
Just a minute. Now, Mr. Kaushik, you have conducted this selection as per 18 rules or 2003 rules?
As per the 18th.
Why?
Because initially, my lord, the 2003 rules.
No. A process which is initiated in 2017,
Right.
can you follow 2018?
No, that's the process which was initiated. In
No.
2017.
Even if you go by Rangaya and all those judgments, although different views have been taken in the meantime, now it is the rule in force, but that rule will, which rule will be applicable will depend on the date of initiation. Initiating midway through, can you change the rule? Admittedly, if you come to page 22, it was initiated on 25th August.
Yes.
Okay. Now read the second paragraph. Director writes to the IS, in this connection, at first you are to ascertain the existing vacant post, which followed. Now you read Rule 15 of the 2003 rules. Before the end of each year, director in consultation with inspector shall make assessment of the number of vacancies. So it's apparent that 2017 rules was followed. 3 rules was followed. Is there any service law proposition that a selection process having initiated under a particular rules, in the meantime, some new rules come into force, midway through, you can change over to the other rule? Is there any such proposition? Because 18 will have another different procedure. So even if you want to do it, you could have abandoned the 2017 process, restarted with the 18 process. Where is 18? Rule 18, rules of 2018.
18 is my lord, page 18. It starts from page 18, my lord.
18 in this book.
My lord. It was notified on 18 September 2019.
So are the two procedures same? Recruitment of headmaster. Post of headmaster shall be filled up by promotion when the graduate teacher so and so. So now a lot of
Earlier it was school-wise selection. Now this is district-wise selection.
That is why we are asking you. The whole concept may change. We'll hear you, Mr. Mohanto. You need not get excited, and you will not allow me to interfere in between. We'll hear you. Now, if we have done that, how do we decide this matter? To decide a matter, we have to refer to one of the rules and then examine whether the procedure had been followed or not. That's what we can do in a jurisdiction, judicial review. Which rule do I take now?
When the selection was held prior to notification of the 2018 rules.
So now on what ground do you challenge now?
My basic challenge is that the private restaurant, he is not a graduate teacher. Number one. Number two, he doesn't have the BA.
These are the two grounds. So we understand that this was completed and he is a man of the same school.
Same school.
So that 1783 and 18 discrepancy will not come into play. Okay, we ignore that.
Interview was conducted on
26/9, 18. And what is the date of 18 rules?
18 rule was notified on September 2019.
September 2019. And the interview was held on?
18.
18. Okay, this was notified in 19. Okay. Sorry,
One fact, what my senior friend is indicating, that is not in our affidavit.
you have to come a little this side. Your voice is not carrying.
One fact that is not clear from our affidavit, that the process of promotion which was initiated under the 2003 rule, none of these candidates, they were selected in that process. Subsequently, the process was initiated again on 4/6/2021.
4/6.
2021.
New process.
New process.
Then what have you done with the earlier one then?
That earlier one did not.
Earlier one, was it abandoned?
No, that earlier process, in the earlier process, neither the petitioner nor the respondent, none was selected.
No. Did you abandon it?
Yes, that.
So where is the order of abandonment?
That not. Our affidavit was not stated, but record was called for. Record was called for.
You produced a record by which you abandoned the earlier one.
Yes.
So now what had happened in that 2018 selection? None of them were selected.
None of them were selected.
So what did you do?
Then
why none of them were selected?
Because of the qualification.
Which qualification?
The petitioner at that point of time, he did not have the requisite qualification.
Which requisite qualification? B.Ed degree. Okay. Petitioner did not have B.Ed degree.
Yes.
Mr. Tamuli's client, petitioner?
Same.
He also did not have B.Ed. What about Mr. Mohanto's client?
At that point of time, the Parangat degree was not considered as a valid degree.
Valid?
Valid degree.
Graduation.
Yes.
Okay. So you have abandoned it. Very well. We go by you. We have abandoned. After that, what happened?
After that, 4/6/2021, inspectors, a letter was issued to all inspectors.
Which page?
My affidavit, my lord, this is IA. In my case, my lord, it was filed.
No, we can't. We can't dig around files here. You have to tell us the page number.
IA 2320/2021.
This is the difficulty we have. We can't, for every document, I can't change my file. You refer to one petition.
Takes up IA 2320/2021.
No, but he requested that I start with district petition 5636. At least to make your pleadings complete.
And moreover, my lord, the record was called for. But I have been told, my lord, the record from the school selection committee is there. Government has sent us.
No. We accept your statement of Mr. Kaushik that earlier was abandoned because none of the candidates were found to be eligible. We accept that. Now you have initiated a new process. This time under the 18. Why did you select Mr. Mohanto's client? And why the petitioners were rejected?
Because of the direction that you also will find. 14/9/2021.
Do one thing, Mr. Kaushik. You argue everything on the basis of the records. We'll go through the records because pleadings are available in a very haphazard manner.
And moreover, my affidavit that is filed by the director is not so complete.
Which page number?
For the director's affidavit, my lord, on the basis of earlier advertisement in the year 2017, election was held in the year 2018. And pursuant to that selection only, the respondent was selected as per their affidavit.
Which page?
Case 41.
41 of the district petition.
Of the IA.
See, we have difficulty in. Again, your case is another petition. Or else you make a paper book so that we have one document to. See, it's very, how do we take my notes? Page number so and so of that petition, page number so and so of IA. Okay, your 5982. Which page?
They are saying that there is a new advertisement.
No,
That is page number 1.
no, let us come. Yes, Mr. Kaushik. Then why did you select Mr. Mohanto's client? What made the selecting authority select Mr. Mohanto's client and reject the two petitioners?
Page 41 of the interlocutory application.
There
is
it appears that different documents, annexures referred appears in different pleadings in 3 different matters, that is 2 writ petitions and 1 interlocutory application. The parties to provide a consolidated compilation of the documents sought to be relied upon in the hearing.
Item 5.
But Metro, which year? 2000?
Because only there is some urgency because if my client is after vacation,
What to do? I wanted to hear you, but I can't spend 5 minutes to find out one document. It's too much of consumption of time. Okay.
This matter is relating to provisional registration of service of the Panchayat school teacher, LP school teachers. And only questions come about the dice code matter. If I take your worship to state, we are page 95.
95.
Page 95.
Yes, 95.
Yes, the loss will find this is number of BLP schools post non-fulfillment of stipulated criteria as per Provincial Service Act 2017.
Oh, where are you reading? Page 95?
Page 95 from top, my lord. Top.
Top number of VLP
My
school.
lord.
Non-fulfillment of stipulated criteria as per Provincialization Act.
Now, the criteria is your location is the right side of the number 1.
Badorpur.
Both teachers, yes, my both teachers name not appeared in the
Okay.
dice code up to.
You are the teachers of this Paschim West Hasanpur.
Present petitioner, my lord, we come to serial number next page, my lord, page 15. Serial number 15, page 96.
Ramakrishna.
My lord. No, Ramakrishna. Ramakrishna. No.
No, Badorpur and Ramakrishna are 2 different places.
Yes, no, that is serially I am coming. The present petitioners, my lord. It starts from page serial number 15, 23, 22, 9 petitioners. 9 is schools, 15 petitions. So schools names.
Why did you file a common petition?
But same government, because in the same.
No, ground may be same, but our judgment cannot be 9 different judgments.
My lord,
We have to dismiss this petition.
My lord,
Misjoinder of causes of action.
my lord, your worship. Just my subject your
See,
worship.
I can hear and pass one judgment. If one judgment will cover everybody, we don't mind. But if I have to write 9 judgments, we are not inclined to undertake that exercise.
But the issue is same, madam.
Issue may be same.
Issue only same, madam.
No,
Whether-
then it ought to have been one petition, we decide one, others would have been followed.
So your mother treated one petition, madam, here.
How can I treat?
But the same, madam, we have, but
How can I treat?
Madam, we have-
Because I have to write the facts of 9 different people.
no, madam, I'm saying, madam, one person, suppose we are going to petition, 18 petitions is almost.
Then I decide
One
petition.
is school.
Then I decide petitioner number 1.
Yeah, that-
Rest I delete it. You file
One
fresh
is
petition.
school, madam. Petition one is school, 2 teachers. One is school, 2 teachers.
Maybe one school, 2 teacher is okay, but we can't mix around so many schools.
No, I understand your worship. I understand also. petition number 1 and 2, it was the same school, my lord. It was-
Okay, now what is your grievance? Both teachers not appearing in dice code.
No, it's called 11, 12. What they are saying about the 11, 12. Law says, my lord, the act says 9, 10. If somebody's name appears, somebody's name, if the school's name appear in dice code up to 9, 10, they are eligible for the
Which act? 2017.
17.
Page-
See, my lord,
Page number?
definition, page number first
किताब से बोलने की है, वही का।
107.
Page number?
Yeah, page 107, definition of
107.
1072 ZB, my lord. Z small b.
Z
Z small b, my lord.
B.
Yes. B for Bengal. 107.
Okay, up to this one, 9, 10.
9. Provided that you lost provided that the dice code shall have to be issued on or before so and so, and dice code issued thereafter shall not be considered for purpose of utilization of service of any employer there. So these are definition of bench law by my schools. Now your lordship going to section 30, my lord, section 3, 108, my.
Mr. Chaudhary, we are not accepting what you are submitting. Why you see dice code up to 2009-10? That does not mean after 9-10 you are not required any more dice code. After that also dice code will be required because dice code shows the existence of the school.
Right.
And what is provided is, suppose somebody does not have dice code up to 9-10, but has it after 9-10, that will not be taken into account. This is the meaning of ZB.
So,
ZB does not say that once you have it up to 9-10, you don't need
it
a,
is not required. I'm not saying so, my lord.
because dice code shows the existence of the school.
Absolutely, your worship is right. Your worship is right, man. I am not saying so, man.
Huh.
I am not saying that.
So, but do we have the dice code in 2011-12 or you don't have?
It is there to show, my lord. Because my school is existent. We are in existence.
Yes, Mr. Phukan.
We are working till today, my lord.
Why this school did not have dice code of 2011-12?
That is the part one of the SSA will be able to say because the entries are made by the SSA.
Now who appears for SSA? Now what do we do? If you have this kind of aspect, why didn't you say in the beginning of the hearing? We would never started this hearing. But after wasting 15-20 minutes, Mr. Bora is indexed. No one dislikes Mr. Bora on being indexed, but tell it in the beginning. We'd have adjourned the time being, taken up some other matter. This 15 minutes is a waste of time. Don't you think this time is valuable for everybody? For the court, it is valuable not because of me, because of the people who are waiting behind for their turn. Yes, Mr. Chaudhary, what to do?
Let the worship, let him come, my lord.
No, you tell us what to do.
Because we have to, because he-
And by the time he comes, I'll forget about what happened for the last 15 minutes. We'll have to restart the hearing again. So this is the reason why I always ask before starting a hearing, is everybody ready? At that time, you remain silent. It's stated in the middle of the hearing, it is stated that Mr. S. Bora, Land Counsel for the SSA, is engaged in some other court. Next item. Adjourned.
Item 7.
Obliged.
Yes, is everybody ready? Otherwise, we don't start a hearing. Are you ready? Can we complete it? No.
Matter is very simple matter.
What to do if people are not ready? You complete it. It's okay.
Item 8.
Ready? Mr. Neville, ready? Means no adjournment in the middle. I find it really difficult.
I have received the instruction matter. We need to file here.
Okay. Mr. S. Neogi, learned counsel for the respondents in the elementary.
Secondary.
Say, praise for how much time?
Let it be after the vacation.
How much time you want to file affidavit? 2 weeks time to file affidavit, list after
It
2
may be
weeks.
fixed, madam, 7.
Date may be fixed or date is fixed.
Fixed, this week.
You have already fixed the date, 7th.
Highly obliged.
Item 9 for order.
This item 9 is. Are you ready or not?
Item 10.
Yes. Contempt matter. Who appears for the contemptors? SMT Chisti. His name appears.
Madam, today he is not here, madam, due to some person.
It's stated that Mr. SMT Chisti, response that contemporary is having some inconvenience. List again.
Item 11.
I have already received the affidavit, madam, which is today I will file.
You want to file affidavit?
Yes, madam.
Mr. I allow NCT. Then counsel NCT prays for how much time?
After 2 weeks, madam. Today I will file it, madam.
Prays for 2 weeks time to file affidavit. You know, just after 2 weeks.
Item 12 for hearing.
Fixed, my lord.
Yes, what is this matter?
The downtown university.
The downtown university.
They have come up with a proposal by filing an additional affidavit.
Yes,
Lordship,
I think you'll have to answer.
Yes, Lordship, running phase 260, we had made given the forwarded a proposal to the downtown, and running phase 261, accordingly they have agreed to let the students complete their course.
400 and 260.
60 and 61.
400, no? Very,
260 and 261.
260 and
261.
461. What is 461?
261, Your Lordship. 212.
261.
Yes, sir.
This is September 2023, some 2 months back.
Yes.
And what was the request?
Request is on 260 page, earlier page.
Yes, they are allowing you to complete the course. Go and complete it.
The program is the matter is 2014.
Sorry?
The
The matter, the issue is 2014 issue, 2014-15 session.
So how can we help you?
Now what happened, the most of the candidates, the girls, and they have already married and someone engaged in.
No, they have given a very fair offer that yes, whatever had happened, we'll allow you to complete. Even the university is agreeing it. You either avail it or we close it. But what can we do?
May pass order, but
No, what order? No, what can we do? You tell us. To your satisfaction, what order do you expect?
because there is only one of from.
No, we are not.
Their affidavit, Lord,
Mr. Counsel, we are not on the reasons.
Yes.
What order you expect? You tell us that.
they need to compensate, Lord, because the.
Compensate in what manner? Number one, why? Why compensation?
Because
See, only misunderstanding is that the director T-board, T-welfare, may not have addressed the issue to the complete satisfaction of the petitioners. Number one. If students, they presume that a course is an illegal course or it is not a recognized course and starts behaving in this manner, and then say, compensate me. Why? Compensation is always a negligence on the part of somebody. Whose negligence and who will compensate? Now the university. Why? They are conducting a perfectly valid course. They have shown every document. See, instead of being so hot-headed, you should have taken up with the authorities. Agitation is not the only course available in life. Agitation and anarchy both are almost same thing. By creating an anarchy and disrupt yourself, you cannot say now later on you compensate me. If you can show something that this course is illegal, that we had some substance in behaving in this manner, we'll definitely take it up. In fact, we took it up earlier also. We asked them, all the respondents. In fact, on the last occasion, we came up with the director also. This is a new director. He doesn't know anything. And your allegation is the director did not assuage us in the proper manner. How do you know? How will you determine the fact that the director who existed 10 years back did not assuage you? Maybe he had done it. Where is the material to show other than your allegation? So you have to take note of the inherent weakness in your case also. Just raising a claim compensation me. Okay, we can allow you a token compensation. Token compensation of how much? 5,000 rupees each. And that too without determination, mind you. Only thing, there is no material to come to the conclusion of any negligence by anyone. Just because you are students, you are hot-headed, you are being misguided by somebody.
They wish to completely contest if anyone.
That offer is there.
Yes, that part.
If anyone wants to complete the course, you go and report before the director T-welfare.
Yes.
He will guide them to the university and the university will allow you to complete the course. That's a very good offer they have given. What more they can give you?
Yes.
In a misguided manner, you left the institute 10 years back. Now say, please come back, complete it.
And if I'm allowed only one aspect, those students among the petitioner who completed the course may not get token.
Sorry?
Amongst the petitioners, those who had completed the course, that 5,000 may not go to them.
No, 5,000 we are not imposing. If there is 5,000, there is, you are not to complete the course also. See,
They open both the options.
no, nothing.
Because if someone not able to complete the course because they have merit already 5 years back, they have merit.
Where is the law that married persons are not entitled to education?
No, they could not complete this course.
Where is the law that married persons are not entitled to education? They are offering you education, nothing else.
They may not be allowed. I have talked to them.
That is your personal problem, not their problem. If your traditional belief is such, a married person should not have education, no one can help you in this world. That's a personal belief. Your personal belief cannot make somebody liable for something. It's a very fair offer they have made after 10 years. Yes, I will allow you to complete the course.
At that time, our prayer to in the expedition that they may allow with a great university, because we have not convinced with that university. In 2014, it was a draft law, and more than 100 of students they admitted here.
These are your perceptions. These are not facts.
And now,
fact will be if that university was an illegal university at relevant point. You show us, we'll entertain your case.
university is not illegal.
Then-
Court, they have no right to offer this course.
Why?
Because in the guideline, now 2-3 students have talked to them, when they apply for the government job.
No. If they have violated the guidelines and you have put you in some other institute, you should not have gone there. Refused it.
This is the duty
Not
of
that
the
after getting into the university.
This is the duty of government.
No,
They
it is,
sponsor us.
that is your duty also.
No, we have no right to admit anywhere because the government sponsor us.
Are we to dismiss the petition with cost? Cost on the petitioners for filing a frivolous petition and trying to continue with it? Let's do that. Bring an end.
Not to be disposed of with their proposal.
That's what, why did you waste 10 minutes for that then? If you want that only. See, time is valuable for everybody. It's not just one litigant has the entire time of the court. And Mr. Dury, make them happy with a token compensation of 5,000 also. But not as a recognition of any legal right being violated. Only for whatever reason, for the inconvenience. Okay? Read and take the 5,000 also. Very happy. But it's better we don't have students like you people. For the university point of view, they'll be happier not to have students like these people. Students behave like students. Don't behave like ruffians on the road. Your primary duty is to study, not to worry about anything else. Heard, Mr. Yes, your name? A.U. Ahmed, Land Counsel for the petitioner. Also heard. Follow it here, no? Mr. B. Dewey, Land Counsel for the respondents number 1 and 2 being the authorities under the T Tribes Welfare Department, Government of Assam. Thengal Kosari, somebody is appearing. Mr. On behalf of respondent number 3 being the authority, for the respondent number 3 being the authorities under the Thengal Kosari Autonomous Council, MSS Sharma, Land Counsel for respondent number 4 being the Director of Medical Education Assam, Mr. N. Dekar, Land Counsel for respondent number 5 and 6 being the authorities under the Assam Downtown University. And AICT, who appears? AICT. Find out. Court means court, not the court building. So if he wants to record it, otherwise it's improper to record.
Okay.
Uh,
Since the students were sponsored by the T tribe and the Bengal Autonomous Council. T tribe and Bengal Autonomous Council. So with regard to the token compensation, sponsoring authority, T tribe will make to their students with those whom they sponsored, and with regard to Bengal, they will make. They have an autonomous council.
You don't want to pay.
No, Lordship, I'll be answering.
No,
for
this
you, my
is
client also.
this is inconvenience compensation, not negligence compensation.
So let them there do their part, our part.
Say inconvenience to pay for their transport from coming to the home to the university to do the course.
They will do. Those students will do.
Will you pay? No, money no one is ready to pay. You pay, you are a government department. They are a council. Council will have very less money. And that to Thengal Kosari, it's a very small council, I think. It doesn't have a very wide jurisdiction. BTC, okay. BTC, they have a wide jurisdiction, they have more money. But Thengal Kosari, so
If they are incapable, they will coordinate us, will do it.
the we'll come back. The petitioner's hearing claims to be belonging to T tribes community, Thengal Kosari community, and Deori community, respectively, and that they hail from BPL families. The respondents through the director of T tribes, what is that? T tribe wealth. Through the directorate of T, the respondents in the T tribes welfare department has a scheme of sponsoring. If it is T tribe, why are you dealing with Thengal Kosari and Deori?
Okay, actually, Deori Autonomous Council do not have any students sponsored here. It has been wrongly inserted.
That's a wrong statement.
Yes.
All 74 belong to T tribe.
No. There are 74 students that has been sponsored. Out of that, 44 petitioners are from T tribe. 44. And 30 are from Thengal. And out of that 44, 13 have completed.
Okay, the Deori is not there.
Deori is not.
No, then why is it sponsored through the director of T and T?
Wrongly, yes.
Page number 21 is the advertisement.
So they are partly sponsored by the director of T welfare and partly by Thengal Kosari Council.
Yes, Thengal Autonomy from the WP.
Okay.
They are also one director.
The respondents through the Department of T tribes welfare and the Thengal Kosari Autonomous Council have a scheme of sponsoring candidates belonging to the respective communities for undergoing certain paramedical courses and they're wholly sponsored. Entire expense is paid. And the entire expenses of undergoing such courses are undertaken by the two authorities. In such process, the 74 writ petitioners, 44 of them who are stated to be belonging to the T tribe community and 30 to the Thengal Kosari community, were all sponsored and admitted to undergo the, what is the name of that course? Under the course of Diploma in Medical Laboratory Technician.
Here is also one aspect, Your Lordship. Actually, only 29 students were for the DMLT, which he had made the statement. Others are from different courses. Not all those, as stated in the writ petition, are from DMLT. But still can let it.
They say the courses and other courses.
Yes.
কি বলবো? And other courses in the respondent Assam Downtown University. Accordingly, the petitioners were admitted to the course, the period. No. Oh, when they were admitted?
14 to 15.
For the session 2014-15. Upon being admitted and after undergoing the course for a certain period of time, an apprehension arose in the minds of the petitioners that the courses to which they were appointed under the Assam Downtown University was not appropriately recognized, and further that the value of the diploma that may be obtained will not lead the petitioners availing any government job opportunity. Upon such apprehension, the petitioners undertook an agitational approach, and in the process, the director welfare, oh, that's why you said 5,000 partly them also,
Yes.
because 44 and 30.
Yes.
You have to pay for 30. Why he will pay for that Thengal Kosari people? In the process, the director of welfare of T and XT Garden tribes caused an inquiry to be made on the apprehensions that arose in the minds of the petitioner, as well as the agitational approach that they had undertaken. The research officer in the Directorate of Welfare of T and XT Garden tribes submitted a report dated, any date? The report dated 7/3/2015 made to the director. Full stop. In clause 2 of the report, the research officer stated that it could not be ascertained as to whether the diploma stroke degree awarded by the Assam Downtown University would result in an eligibility to apply for government, apply for jobs in government establishment. It is stated that the said report, inquiry report, was also made available to the writ petitioner students, which further led to the intensification of the agitational approach. Ultimately, the writ petitioners state that as because of the uncertainty in their minds, all of them left the course midway through. In the circumstance, this writ petition is instituted, claiming appropriate relief, including compensation to be paid to the petitioners. Apart from what is noted above, no further material is available before the court on the assertion of the writ petitioners. The respondents, Assam Downtown University, has produced all the relevant materials, including the recognition given by the UGC as regards the courses that they are offering. And the examination of the documents produced do not reveal in any manner that the respondent Assam Downtown University were not duly authorized to offer the courses to which the petitioners were admitted. No material is available that the students had even approached the authorities of the Assam Downtown University for a clarification as regards the validity and acceptability of the courses that is being offered and the petitioners subjected to. MS.S. Sharma, Learned Counsel for the Medical Education Department of the Government of Assam, has produced certain advertisements for recruitment of the paramedical staff in respect of jobs available under the Government of Assam. And such advertisements also indicate that persons having the required qualification from the respondent from the Assam Downtown University are also eligible to apply for such in such a recruitment process. As it is the specific stand of the authorities in the Medical Education and Health Department of the Government of Assam that the persons acquiring the qualification from the Assam Downtown University are also eligible to participate in a selection process as well as to be offered a job, government job under the Government of Assam, the initial apprehension in the mind of the writ petitioners that the value of the diploma degree that they would obtain would have no value for the purpose of acquiring government job had undertaken any effort to get it verified from the authorities of the Medical Education and Health Department of the Government of Assam as to whether the qualifications that would be obtained from the Assam Downtown University would be acceptable to the Government of Assam or not. Considering the two aspects, it appears that the entire apprehension in the minds of the writ petitioners were not based upon any credible material, but it was more of the state of an apprehensive mind of the students. The only confusion that may have been created was the inquiry report of the research officer, where it was stated that it could not be ascertained as to whether the diploma degree holders from Assam Downtown University are eligible to apply for government jobs. From such point of view, certain lashes are noticed on the parts of the authorities of the Department of welfare of tea and ex-tea garden tribes, inasmuch as a more effective endeavor was found to be missing to ascertain the acceptability of the degree diploma offered by the Assam Downtown University. And also, if the inquiry report itself is incomplete, the same ought not to have been made available to the students to add to the confusion. In the circumstance, Mr. E.U. Ahmed, Land Counsel for the petitioner, insists upon that in the meantime, as 10 years have passed by, some of the petitioners may have been married and others may have ventured into some other vocations, and therefore they ought to be compensated for having been prevented from acquiring the qualification of diploma in medical technician courses for which they were admitted. In such circumstance, by our earlier order dated 19/9/2023, we required the respondents to make their submissions as to in what manner the grievances of the writ petitioner students can be taken care of. In response thereof, Mr. B. Dewry, learned additional syndicate advocate, junior government advocate, appearing for the Department of Welfare of Tea Tribes and ex-tea tribes, refers to a communication dated 29/2023 from the Director, Tea Tribes and Adivasi Welfare Assam, made to the Chairman and Managing Trustee of the Downtown Charity Trust, wherein the factual situation was narrated and the authorities of the Assam Downtown University was requested to allow the writ petitioners to continue and complete the respective courses free of cost. In response thereof, the Assam Downtown University, by their communication dated 21/9/2023, had informed the Director, Assam Tea Tribes and Adivasi Welfare, that they are agreeable to accede to the request to allow the writ petitioners to continue and complete their respective courses. From such point of view, the legal injury that may have been caused because of the slight aberration with reference to the inquiry report appears to be well taken care of. In such view of the matter, it is also taken note of that out of the 74 writ petitioners, 13 of them in the meantime has completed their respective courses.
Of the tea tribe. And with respect to Thengal, they will know that whether what is the status.
13 of the writ petitioners belonging to the tea tribe and ex-tea tribe have completed their respective courses. Thengal? Completed. Should I record it? The council for the Thengal Kosari Autonomous Council also makes a statement that as per the information provided, some of the students belonging to the Thengal Kosari community had also in the meantime completed the respective courses. The very fact that some of the writ petitioners have in the meantime completed their respective courses also is an indication that the incident that is relied upon may not have impacted the completion of their respective courses. From such point of view, the offer of the respondents in the T-Tribe and T-Tribe Welfare Department and some downtown university to allow the rest of the students, if they desire, to continue and complete the courses appears to be a reasonable offer. But however, Mr. A.U. Uddin, Land Counsel for the petitioner, states that A.U. Ahmed, Land Counsel petitioners states that in the meantime, some of the writ petitioners may have changed their vocation and some of them may have got married in the meantime, and therefore it may not be convenient for them to continue the courses. If it is so, it is the personal issue of the respective petitioners who do not intend to continue with the courses. And no material has been produced that because of the incident which is an issue before the court in this writ petition, any of the writ petitioners are now required to lead a life of despair to the extent that their entire career had been brought to a knot. In view of the above and in view of the offer indicated in the communication dated 29/2023 of the Director T Tribes and Adivasi Welfare and the reply of the Assam Downtown University dated 21/9/2023, we provide that any of the writ petitioners who had not continued and completed the course, if they desire to approach the approach the Director T Tribes and Adivasi Welfare Assam in respect of the writ petitioners belonging to the T Tribe and before the authorities in the Thengal Kosari Autonomous Council in respect of those writ petitioners who belong to the Thengal Kosari community, and the two authorities shall do the needful and coordinate with the Assam Downtown University to facilitate the process of the writ petitioners who so desire to continue and complete their respective courses. However, as indicated above, although no negligence per se is noticed in respect of any of the respondents, which appears more to be a misunderstanding between of the students of the prevailing situation, but also having taken note that certain inconveniences had been caused to the writ petitioners, a token compensation of ₹5,000 be paid to the respective writ petitioners, to all, paid to everybody. Those who completed also, they also faced some inconvenience. They completed later on. But something happened, they were disturbed.
It was due to the environment they had joined the otherwise.
Then we are going to hold you liable. Why did you disclose that inquiry report? You'll be in bigger trouble. You'll be in bigger trouble then. If you are firm, we can also be firm.
Respective sponsoring agencies.
Because why I am saying this is given not for any negligence, because for the inconvenience. Inconvenience is caused to everyone. Whether you have completed or not completed, inconvenience is caused to everybody. Because they were in an agitated mind, at least for some period of time. So, each be paid to all the writ petitioners, to be paid by the Director T Tribes and Adivasi Welfare Assam in respect of the writ petitioners belonging to the T Tribe and ex-T Tribe, and by the Thengal Kosari Autonomous Council in respect of the writ petitioners belonging to the Thengal Kosari. We are making it clear that the compensation is a token compensation in recognition of the inconvenience caused, rather than it being a compensatory compensation for any negligence on the part of any of the respondents. It's not for negligence. Petition disposed of in the board.
In the respective accounts.
No, they'll have to go to you. You pay them. If they don't go, don't pay. The compensated to pay as per the approach of the writ petitions before the aforesaid authorities. Where will you find them if they don't come to you?
Item 13.
Lordship, in that.
Anything other than adjournment.
Just pointed one.
No, no, that's why we are making it very clear. Anything other than adjournment. If it is adjournment, rejected outright. Yes, Mr. Yes. Because a 2013 matter cannot be repeatedly adjourned. It's adjourned for more than 100 times till now. We are not putting on anybody. And the last date, it was made clear that under no circumstance any adjournment, we stick to it. Yes. If you are interested, you argue. If you're not interested, you may not.
Yeah, I have also filed our affidavit, Lordship, yesterday.
Doesn't matter. Who asked you to file after 13 years? We may not take note of it also. And if you want, they can bring it. Up to you. Then it's okay. Then you argue.
But I'll just recap. But your Lordship has got so many.
So,
I'll just recap very
moment I'm looking at you, everything is recapped.
Your Lordship,
Because
your Lordship,
number of times we went through it.
Your Lordship will remember. My Lord, initially the petitioner filed the company petition against the mismanagement and operation.
Do I follow the procedure of hearing everything that has to be said?
No.
Or I try to regulate it
Yes, yes.
by which procedure I follow?
No, your Lordship will regulate. Your
No,
Lordship's got
not
to-
prerogative. Where you will be comfortable.
No, I'm comfortable, my Lord. The way
See,
your
one
Lord-
way is I just go on hearing everything that is argued from both sides. Other way is we try to regulate. Which one will be better?
I
More
think your Lordship-
comfortable.
Your Lordship has heard enough. And at one point of time, your Lordship decided that the matter will be sent back to CLB. CLB is not there, NCLT, they will decide. At that point of time, they did not agree. And your Lordship said, okay, we'll decide it on merit. So my submission is just one line. After the case was disposed of, in that order only liberty was granted us to approach. We
No,
approached.
why I'm saying regulate, I just want to hear from both sides on one aspect of the matter. Forget about this case. Don't refer to the facts of this case straight away. In law, what it will be? A proceeding is initiated. Parties appear. Ordinarily, the proceeding has to be decided. Either you dismiss it, or you allow it, or you take a third view, or you, whatever you do something. It has to be decided. There is also a particular method of bringing a proceeding to an end by a compromise order. That's one of the accepted methods. Once it is a compromise order, either the parties adhere to the compromise or they get the compromise executed in some other proceeding. It has to be a third proceeding, means a subsequent proceeding. The violation of the compromise. At least in my experience, I have not come across a situation where after compromise, the compromising authority continues with the proceeding. Where does the compromising authority get a jurisdiction after effecting a compromise, to further continue with the proceeding. Yes, it is possible. It will be possible on an acceptance by both the parties that the compromise that was arrived at becomes a non-existent.
Will be subject to further.
Moment we arrive at that situation, the original proceeding has to be decided on merit because of the failure of the compromise. This is slowly going against you. Now, under which principle of law the matter will be decided from the stage of the compromise, that who had violated the compromise, who is required to do what out of the compromise, and then I decide the original issue. You can say, I am deciding the violation of the compromise. You don't have the jurisdiction to do. Because moment the compromise was arrived, that authority becomes functus officio. It does not have jurisdiction anymore. Moment you feel I'm continuing with your jurisdiction, only jurisdiction you have is to decide the proceeding. And if I am remember rightly, in this case, the proceedings happened in such a way that by a given order, a compromise, whether it was agreed or disagreed or imposed, I don't know, there is a compromise. You'll do this, you'll do that, this.
May I sit for a moment?
Yeah, definitely, please. No, you can sit and argue also. We have no difficulty. I think, should we hear on that issue first? Because we don't have much to hear because the proceeding is not decided. Number one, we cannot decide in a read the original proceeding. Or else we decide the acceptability of the subsequent orders of the tribunal, NCLT. I think NCLT, no?
Company law board.
Company law board. Post compromise. Before deciding the validity of that order, we'll have to decide the jurisdiction of the board to carry forward. And if there is any such proposition in law, please produce it. We'll definitely, we are only framing a tentative issue because at least I have not come across any situation where after effecting a compromise, the same authority retains jurisdiction. Is it in law available? Is there any proposition on that?
Some judgments have come across where
No, sometimes we do. No, see, no. Sometimes we do it. Suppose in a PIL, the court decides some issue that it has to be done that, then keeps it pending for monitoring the implementation of the order. That is a totally different circumstance. But compromise.
If you would see, but the appellant has gone before the company law board, but invoking the.
No, just a minute. Appellant has gone to the company law to get his matter decided.
Yes.
Once the matter is decided by result of a compromise, it's a compromise. The jurisdiction and authority of that authority comes to an end then and there. It does not retain any further thing to keep on pressurizing or directing or doing this or that, or he had not done that. After not having done that, I'll now decide the rights of the parties as per the compromise, not as per the original claim. So here we have two stages. One, compromise, then deciding the rights of the respective party through the compromise.
I restrict submission would be limited aspects. Where we see the initial issue that was raised before the company law board was operation and mismanagement as regard the claim of the appellant. During the hearing, my lord, in fact, in that case, my lord, even the company was not made a party respondent. This is beside the point.
No, then you take a plea, this proceeding is not maintainable. Dismiss for non-general necessary party.
My lord, thereafter, what has happened? My lord, the parties have entered into a compromise on the request of the my lord, presiding officer. My lord, this is where there is a possibility or not. On the possibilities of compromise, my lords, there had been several proceedings based on which my lord, there was certain dispute as regards the shareholding, which ultimately culminated in an affidavit.
No,
filed by us.
no, we understand that. That's what we are trying to point out to you. Where is the proposition of law or provision of law that after effecting a compromise, the authority retains further jurisdiction in the matter? See, today, after delivering a final judgment, can I retain jurisdiction over this appeal? Can I keep on sitting from time to time in this proceeding? That this was my what I have provided him in an order. Mr. Dubey, did your client do that? Can we expect the court to sit? No, because the proceeding comes to an end at that stage. Same, it happened with in this case. Either it's a final judgment or it's a compromise order. It's a finality in the matter. As per that proceeding is there. Of course, there are various provisions of law. What do you do with a violation of a compromise? That's another totally different set of law. If he had violated, it will go to some other proceeding, not to this one.
The consequences are also there in the concept. Beside that one.
Then, just a minute. In that case, it was not a compromise. If it is not a compromise, where is the final determination?
It was a compromise, and the board has retained its power.
How would no? Where do you get that so much of power to retain your thing?
Some of the cases, this power has been provided.
Where? Please produce the proposition of law. We are asking you that only. Show us. How a judicial authority retains jurisdiction over the same proceeding once it is compromised. Compromise, we understand, is a finality, always a finality. It's never a, or else other option would have been, sometimes we also do it. Say we request the parties, see if it is possible for you to sort it out. And parties come back to us, yes, we have sorted it out. We record the agreement and we close it. Or the parties are unable to arrive at a, that case, what we do? We decide the original dispute. So now, at the best, this can be a compromise which was initially arrived, but subsequently, you are unable to arrive at a compromise because either of the parties is not doing something. So now it's a responsibility of the authority to decide the original matter. They can dismiss it. That's a different thing. In deciding, they can take note of subsequent events. That is also permissible in law. But you have to decide it. Now, why you are putting this question? As an appellate authority, now you are asking to decide something which prima facie appears, not whether it is right or wrong, whether it could have been done or not. You'll be arguing that they have done the right thing because why these are my reasons. Mr. Mishra will be arguing, no, you've done the wrong thing. These are my reasons. But question is whether you could have done it or not, rightly or wrongly.
But so far as this issue is concerned, it's more on the appellant to say that this is possible. But we are also saying that this is possible and this has been done. Because the provision
Show us the law. If you have the law,
I'll place it.
place it. First you place it.
Now, right now, but I have
find out some judgments, my lord, which say that working out is possible. Not else placed before your lordship. And they
Give us the proposition of law that proceeding having compromised with an order, after the compromise, the same authority retains jurisdiction to continue with it.
not that. But my broader submission on that line.
No, brother, first we go there.
My lord, that-
Because this is the core of
I
the
understand.
jurisdiction of the appellate court. Then we go to other
my lord, I
aspects.
So that is the, because if that doesn't.
See, Mr. Dubey, we cannot allow you to say that the trip was enjoyable. When you were asking the question whether trip could have been made at all or not, first answer whether could have been made. Then you justify that it was a very good trip.
Lord, I would rather say, my lord, they initiated the trip, my lord.
We are on simply on a question of law, nothing else. Can it be done? Do you have any proposition?
No, my lord,
Because any compromise, I think it brings an end to a proceeding.
my lord, in civil case, I can give an example. If there is a suit which is decreed on compromise, then as your lordship said.
Even there is no appeal to that also.
Yes. So then the court becomes functus officio and it will be executed in case there is failure.
No, in a civil case, even the appellate authority doesn't have a jurisdiction,
Yes, then because
let alone the same authority.
because from consent order, no.
I think
compromise order,
it
no
should
appeal
come to an end.
rights. No
So
appeal
once it comes to an end, all orders of this authority, subsequent orders are orders without jurisdiction.
Yes.
So we are not required to examine whether they are right orders or wrong orders. It's an order without jurisdiction, it goes.
Only question would be, it's in your lordship's mind, I'm sure. Your lordship has already spelled out. If it was an order by which it is disposed of on the basis of the compromise that has arrived at without saying anything. But then to give a rider, specific, if there's any difficulty, come to us.
No, moment it's a rider and it's a not a compromise,
It's not
that
a-
means it's a not a compromise. If it's a not a compromise, there has to be a
not a
final
final order.
final decision on the matter.
That's the crux of it. That's the crux.
In fact, my lord, in some company matters, my lord, this kind of orders have been passed my lord, and decided also.
See, somebody does it doesn't mean it has to be done. It has to be backed by law.
That is the starting point of the whole.
Say some act is not backed by law, somebody does it. That doesn't mean it will be binding on everybody, then you also have to do it this way.
That's not.
Then that will not come. If nobody assailed the earlier one,
We will face judgment
It
before your
goes
lordship,
that
Lord, in
way.
company matters and more so in family matters like this, my lord, this working out or gaming of.
no, how company and family are different from general law? Is there is a reasonable classification of method of deciding a company matter and a family matter from any other kind of proceeding? I think proceedings are proceeding.
But in my lord,
Unless the statute itself provides for. Some proceedings, a deviated method may be adopted, but that is normally statutorily provided. Otherwise, on your own, you cannot create a classification as per convenience that family and company are different. So the general laws of adjudication will not be applicable.
remember one judgment of affidavit, that also I'll place on that. my lord.
Place it. Come forward with
Yes, I
laws.
understand what the basic.
I don't say you are wrong, maybe right also, but you have to substantiate it.
Can you take it day after
Why not today?
this time? Take it day after.
From now on, it's a cost of 50,000 per adjournment. For whatever reason.
Let it be day after day after, my lord, if I pass.
If you see, the public exchequer bears a huge cost for every listing of a matter before the High Court. For these kind of adjournments, we impose that cost to be deposited in the public exchequer. Do you know the expense? We very casually say the matter will be listed. The total expenditure the public exchequer bears, considering everything, and the number of litigations, what is the cost of every litigation? The cost of listing every litigation. It's a huge cost. Take the adjourn and pay the cost.
I would have tried at 2 o'clock, not some other matters I'm fixed at 2.
What can you do? Order 17, Rule 6. Council busy in another course is not a ground for adjournment. It's against the statute again. And why the other matter always more precedence and this 2013 matter always in the back burner? Why?
But we can make a request. In fact, this morning that I have made a request.
So what to do?
That was fixed.
That's inherent difficulty learned busy lawyer may face in course of their profession.
But there are judgments.
Produce it. Give us.
Then you lot me take it to
If you are busy, don't come. At least give us the judgment
Yes,
so
yes.
that we can at least start reading it. What is the law, Mr. Mishra, on this?
So, no, there are something.
Sorry.
After COVID, I am really.
No, any on this law?
But, different times now, I'm having sleeping disorders. The last 2 months. Sometime, even after the pills, I don't get sleep. This is what has happened last night.
Oh, what happened?
No, even after pills, I don't get. It's kind of insomnia. Then even after pills, sometimes I don't get, and it happened last night.
Okay.
I don't know, something wrong with the kid, but even then I.
So on your health issue, want it some other day?
No, if you say day after, you got.
No, on your health issue, we can accommodate. Let's we do.
If it can be taken
That's a totally different
day after,
consideration.
it's fine. It's fine.
Thursday.
Yes.
Adjourn on the prayer, Mr. R. Dubey, and counsel for the respondents on the proposition of law as to whether after a compromise has been effected, whether the proceedings attains a finality or in the guise of monitoring the compromise, the original authority retains further jurisdiction on the matter. Thursday.
Yeah.
14.
Borketri College.
Yes. This is the last straw so far I am concerned.
Which petition? 2891.
2891.
2891. I think it started too. It's hardly 1 more minute. Should we start? It's hardly 1 more minute. This matter, it will be an independent decision or it will be intricately connected with some orders we have already passed. Independent.
Short issue.
No, why I'm asking, suppose it is connected, in one matter we say something, in this one we say another thing, it won't look very appropriate.
But this is independent.
Absolutely
Only
independent.
between a dispute between 2 professors.
Understand? This is absolutely independent. It will have no bearing on any other. Okay.
May it please your lordship. My lord, the petitioner was appointed as a lecturer of Geography Department of Borketri College at Mukalpur, Nalbari. Now those posts are known as assistant professor. The date of appointment, your lordship will kindly note. My date of appointment was 9/11/2000. And my joining report was 10/11/2000.
So where is the appointment order?
At page 16 of the petition, madam. The type copy is, Chairman, at page 16.
College was venture that time.
Yes. Then 17 is the original. That's why it was not very legible. That's why I gave the
Yes, yes.
type copy. Page 18 is my joining report, 10/11/2000. The original is at page 19, and my lord, at page 19, your lordship will find at the bottom left the endorsement of the acceptance of the joining.
Allowed to join.
Now your lordship will see the staff particulars of the time at page 20, where your lordship will find that I was occupying the third post of lecturer of geography. My lord, your lordship will find the serial number 1 is Motiur Rahman, Mohammad Niaul Haq, and Mohammad Azad. I am Mohammad Azad. Your lordship will find date of joining 10/11/2000 is there.
Yes.
Here in this staff particulars, your lordship will not find the name of the respondent number 4. Then your lordship will
This
find.
is a particular as on which date?
My lord,
Mm.
this is the type copy of page 21.
14 something, no?
Yes,
What is
yes.
the year? No.
14/3/2001.
2001. So this is of 2001.
Yes, ma'am. Then your lordship will find the resolution of 4/3/2001 at page 22. Page 22 at the bottom, serial number 11, Mohammad Azad Ali's name is there. And the original resolution is in vernacular is I have annexed at page 4 to at 23 to 24. Then your lordship will find the extract of the submission of the proposal as per the governing body. There also your lordship will find at page 626, Mohammad Azad date of appointment is 10/11/2000. And now for the first time, your lordship will find Dilip Chandra Haloi, the respondent number 4, date of joining is 27/2002. Now your lordship will look, this is again at page 29. Page 29, the particulars of the teaching staff. At serial number 25, Mohammad Azad name is there, madam. And date of joining 10/11/2000. Dilip Chandra Haloi, MA 10/7/2000. Now, your lordship will now see page 32. Where for the first time, 9/6/2010, for the first time, my lord, your lordship will find at page 33, the broadsheet. Your lordship got page 33.
Who is appearing for the college?
College, my lord, he was appearing on the last date, my lord. There was Chucky. Now, if your lordship looks at page 33, at serial number 19, your lordship will find Mohammad Azad Geography, resolution number 2 of governing GM meeting held on 4/3/2001, and my date of joining is 10/11/2000. Suddenly, I find, my lord, that this respondent number 4, Dilip Chandra Haloi, he is now date of joining is on.
Understand. We wanted the council for one thing. We have noticed something. Who is for governing body?
Chucky.
Where is Zakir?
On the last occasion, when he appeared before this honorable court, when a German was also summoned.
So, Mr. Mohanto, how this is possible if you come to page 33? Haloi, resolution 13 GB held on 21/12/2003. How he joined on 10/11/2000 then?
Yes. Well, there appears to be some mistakes. There appears to be some
Appears to be
mistakes.
something if you're
Incorrect.
appointed in 2003, how can you join in 2000?
No, I was appointed on the same date along with him, and I joined on the same very day. this issue has been settled by the director by person order of this honorable court.
We'll go to it.
Yeah. So there was a mistake.
Anyway.
Apparently, there was some mistake.
I'll show you how that has occurred, because I have nothing to hide, man. Now your lordship will find then at page 36, my lord. Your lordship will omit the first 6 lines. He states that lot of irregularities are done in regard to the appointment of teachers in the department of
Page 36.
36, my annexure 7. Oh, this is the abstract of the GB meeting held on 18/12/2001. My first 6 or 7 lines your lordship can omit. He states that lots of irregularities are done in regard to the appointment of teacher in the department of geography, where Dilip Chandra
Where are you reading? Geography. He states that.
He states that
He
lots of
means-
irregularities are done in regard to the.
No, who is this he?
He means, my
He
lord,
also says he is
your
Mubarak Hussain.
Mubarak Hussain, the principal, my lord. who has
Principal
also filed
Mubarak
a-
Hussain states,
Because in 2000, Mubarak Hussain was the principal when I was appointed. And in the appointment letter of the respondent number 4, the Mubarak Hussain signature was forced. He filed an FIR. I will come to those later on. He says that I have never appointed this respondent number 4. He states that lots of irregularities are done in regard to the appointment of teacher in the Department of Geography, where Dilip Chandra Haloi is shown to have similar date of joining with Muhammad Azhar. But according to him, Dilip Chandra Haloi was not appointed by him when he was principal of the college. Because in 2000, Mubarak Hussain was the principal man. Then last paragraph, my lord, Diwan Nazrul Islam, a member from the teacher representative, states that he has come to know for the first time that Dilip Chandra Haloi, Department of Geography, was not been appointed by Mubarak Hussain. He is seeing Muhammad Azhar, Department of Geography in the college long before Dilip Chandra Haloi joined. According to him, it is
Mr. Kaur, where is the appointment of Dilip Chandra Haloi? The appointment letter?
yes. And in this case also, we also will look into the affidavit in opposition filed by the respondent.
No,
number
we'll go
4.
it over.
Yes, madam. Yeah, just
Where is the appointment letter of
yes, madam, I'll give
Haloi?
it. It is at page number 92. Now this is continuous page. madam.
92.
This is
So
9.
this is supposed to be signature of this thing, Mubarak.
Mubarak. He says that this is a false and fabricated document, and FIR has been filed, charge sheet has been filed, forensic evidence came that this is fake. And those are part of the record I can refer to.
Where is the forensic report?
Yes. Your lordship will look at page number in the serial page to whatever, no? At page number 178. At page number 177 is the type copy, man, your lordship can see. These are all given with along with the charge sheet, man. 177 is the type copy.
Now,
Now your lordship
which
can-
one is red enclosed and which one is blue enclosed?
Yes, ma'am. But before that, your lordship will kindly read for the.
No, let
Yes.
us understand.
Yes, yes.
Which one is blue, which one is red?
Your lordship.
Is it at page
Mine is a
176?
photocopy. Your lordship may find that explanation in the charge sheet at page 179.
No, let us look at the report.
Madam, mine is photostat. It will always be black and white.
Just a minute.
why your lordship has to look into the charge sheet there, because here the color will be always.
No, charge sheet is not a document you
yeah.
can rely on. Charge sheet is somebody,
Your
what
lordship,
they understand.
Your lordship has.
So, but if the dispute is whether this appointment letter at page, what was the page? Appointment letter at
Page
page 92 is a genuine document or not, I think that's an issue.
Yes.
Because the respondent is claiming appointment as per that letter.
Yes.
The author of the letter comes and tells before one authority that it is not his.
Including before this honorable court.
Understand? Matter goes to the forensic. Forensic gives an opinion. I think we stick to that.
Yes. But
But how do you understand
yes, madam.
which is A4 and which is?
Yes, well, I'll come to that. My lord, your lordship will kindly pause there for a moment. Your
Why-
lordship
why-
may
why-
kindly look at page 179. I'll come. I have anticipated mine, but your lordship will kindly look at page 179 for a moment. Again, I will come back here. I am not avoiding that answer. I'll come back. Your lordship. Page 179, your lordship got it. The
Yes.
broadsheet.
But charge sheet we can't.
Yes, no, your lordship will kindly see because.
Mr. Kumar, fundamentally, we are deliberately not looking at the charge sheet for one reason. Charge sheet is a document by which a charge has been made against a person.
Yes.
It is not the conclusion. And here what we will be doing, we'll be arriving at a conclusion.
Yes.
So a charge sheet cannot be the basis to arrive at a conclusion
Yes.
where the document itself is yet to be adjudicated upon.
But
So that is the reason I'm
but-
deliberately avoiding. But at the same time, we can definitely place reliance on a forensic report
Yes.
where there is a issue as to whether the person concerned has signed or not.
Yes.
So
The
therefore,
author
I'm giving.
of the document, you statement, I will take your lordship.
Uh-huh.
Your lordship will just look at one line reference at page 181. The last 4 lines of 181.
But this will not help you. Understand, it will not help you because
I'll come. Your lordship will just for 1 second. Your lordship will see the page 181. As per the FSL report, it has come to note that the accused Lokman Ali fraud the signature and
Mr.
appointed this.
Kaur, that is precisely
that
we
is,
are
yes.
trying to do.
And there is an affidavit.
Because under the law, charge sheet is the opinion that the investigating
Yes.
authority may have arrived at. That is not binding on the court.
Yes, ma'am. Your lordship will see the affidavit filed by R5.
Who is R5?
R5 is one of the Mubarak Hussain. His affidavit is before this on
Page number?
144.
144.
Your lordship got it, page 144.
Hmm.
Now your lordship will first see my contentions at paragraph number 3. That with regard to the statement made, the deponent admits that the letter of appointment of the petitioner dated 9/11/2000 was issued by him and that he was the principal of the college at the time of appointment and joining of the petitioner. Now your lordship will see paragraph number 5. That with regard to the statement made in paragraph 9 of the petition, the deponent state that it is a fact that he filed the FIR dated 29/12/2011 in the Mukalma station against Mohammad Lokman Ali, as he had forged the deponent's signature in the appointment letter of Dilip Chandra Haloi. The deponent states that he had never issued any such appointment letter in favor of Dilip Chandra Haloi during his tenure as principal of the college. This is the affidavit coupled with the fact of the FSL report.
Why
saying that-
Mr. Jakir is not coming to the court? If no one is there, let the principal of the Borkhetri College remain present with the records. What are we out?
Your lordship, can you give me 1 minute? I have his phone number and then they can put that.
See, we directly want to go into the issue that is raised. According to you, respondent number 4 was not appointed by Mubarak Hussain as per the appointment letter at page 92.
Yes.
Mr. Mohanto will try to defend, saying that he was appointed. How do you decide the issue? If the matter had already been sent to the forensic, we want to examine the original records of the forensic, whether it indicates that it is a fake or it is not a fake.
But that,
If it is a fake,
yes,
couple with the affidavit of this Mubarak Hussain,
yes,
we'll form some conclusion.
because your lordship will not go, because your lordship knows that if your lordship is prima facie satisfied by applying the doctrine of preponderance of probability that this document is fake, the matter ends there. So for criminal case,
No. We have to arrive at a definite conclusion,
Yes.
whether it's fake or not.
yes,
If it is fake,
yes, ma'am.
we will not look into this document for the purpose of establishing any right by the respondent.
Yes, ma'am.
If it is not fake, we have to take on board this document also.
My lord, so far that record is concerned, my lord, the common advocate can bring the case diary from the Nalbari court, which is lying with the PP, the original case diary, because it is not in the court, it is with the concerned PP.
Yes,
So he has to bring it from the concerned.
Yes, Mr.
No, government.
No, because if it is a matter in criminal court, I think PP has a jurisdiction. That's why he's saying.
Because the case diary is at the moment lying.
I think that's an issue.
And as a result, my lord, what has happened? Because why he has.
Ultimately, we are called upon to determine seniority.
Yes. No, my lord, there is one catch to it. Suppose why this has been done, because if the date is same, this 2000, then in age, respondent number 4 is senior. And by doing the same date, he is enjoying the benefit of provincialization from the date of his provincialization, and he is drawing all the benefits.
Just a minute.
And this case was filed in, my lord, 2014, my lord. Although there was some interim order under which they could not have done it because there was a status quo order also, my lord. We have annexed that status quo order, my lord.
If we compare the signature at page 17 and page 92,
Yes, my lord.
I think it will serve the answer. Page 17 is your appointment letter under the signature of the principal, which is, and the principal himself admits that he had issued it.
Yes.
Page 17 is the appointment order relied upon by the respondent number 4. So if the two signatures are matching,
Your lordship may look
Mr.
from the original appointment letter of the respondent number 4. Because here in the photo state it is not legible.
definitely. Mr. Gogoi, instead of relying on some criminal case, why don't you send it matter to the forensic once again? That
Report is already.
respondents to provide the original of page 17 and page 92.
Well, probably that original must have been changed with the police.
No, if it is seized, it can be brought back. A court can always order it to be brought back and again returned back. It cannot be that it is seized by police, so it's a sacrosanct document, no one can look into it any further.
So, my lord, what I submit before your lordship is that your lordship will direct the PP to bring the case diary of that case.
No, we are not
Then
interested in case
the
diary.
original appointment letters of both the parties will be there. And
Mr. Gogoi, what we intend to do, ask the college authorities to provide the original of page 17 and page 92. Both are dated 9/11/2000. Both are signed by the same principal. On affidavit, principal says, I signed page 17, but I did not sign page 92. You produce the original. On our own, we'll make an inquiry. We'll send it to the forensic. We'll take their report, and the issue will be decided accordingly. And wherever is the original, we are passing this order. Get hold of that original, hand it over to the registry. Registry will give it to the forensic, and we'll want a report.
Regarding that original record, My lord have passed one order in WPC lordship, this one also lordship, 10/8/2018.
Mr. Gogoi, why again go for indirect methods if you are ready to?
Original record is not there also.
What happened to the record?
So lordship has directed us to investigate the issue lordship, and accordingly we have.
These appointment letters are not available.
Not available.
What happened?
Record is lordship, there is a dispute between there is an internal dispute, so records are missing in that particular college. So lordship in the series of method, my lord had directed us the director to lordship examine in lordship, go to conduct an inquiry.
Then suppose the record is not there. Are the resolutions of the governing body available?
That part also, so lordship has directed us to an affidavit.
So preceding an appointment letter, there must be some resolution. Without a resolution, there cannot be appointment letter. But if this 1911 of respondent number 4 is preceded by a governing body resolution, understanding can be that it may be one. Because difficulty is the name Borkhetri College.
That is the reason, Lord.
The name Borkhetri College itself.
For this record, Lukman was sent to even jail. The SP picked him up, sent to jail, but even there they could not trace out the hit. They have destroyed those records, my lord.
As per Lordship's direction, we have filed affidavit in WPC 113/2015 Lordship. Montu Kalita in the series of cases. Lordship has directed us to conduct an inquiry, Lordship. Accordingly, Lordship has directed us to reconstruct the record, Lordship.
Reconstruct will be all photocopies.
Reconstruct.
But how can we determine the signature in a reconstructed
That part
report?
we cannot look. Reconstruction part is on the basis of the documents submitted by the petitioners, Lordship. The original records are missing, Lordship.
And even in the case of respondent number 4, they have not annexed the governing body resolution, which is referred at page 126, my lord, of the affidavit of the. Your lordship will kindly see page number 126 of that page, my lord, 126 of the affidavit filed by the respondent.
Evidence check on some.
If Lordship permit, I can hand over the earlier. Only one paragraph.
No, we take your word. It's not there. No, Mr. We accept what you say.
Lordship. Pending cited in 113. That's what give my question. See on the sector examination as to documents.
This Mubarak Hussain is still alive.
Yes. Yes.
Can we invoke section 73 Evidence Act? Evidence Act.
A comparison of signatures.
76.
73.
73. 73 possibly will need the original. Yes, Mr. Dhor, for section 73, can you do the reading on a photocopy or you need the original? Section 73 Evidence Act.
Probably Lordship, origin is required.
If origin is there, we send it to the forensic. Why will you do it the reading ourselves?
Then Lordship, that part is there, dark code.
But how do you, Mr. Gogoi, how do you explain page 33?
33 to institution Lordship.
Page 33.
In the resolution को resolution को define 21/12 appointment আগত আৰু resolution এটুকু এখানে কোৱা
It is also retrospective. The effect is retrospective.
No, that's why I'm asking.
That if that is the story Lordship, that cannot be Lordship.
No, but in this college, it's a peculiar college.
Lordship,
You come to entry 17. Date of joining 10/5/1998 and appointed by GM held on 4/3/2001. They have the habit of doing that.
Lordship.
It's not that only in one case it is done.
Lordship.
Then again, same applies in serial number 18 also. Not only that, in respect of Azad also.
98-1.
Azad
Azad also Lordship.
also 4/3/2000, but joined on 10/11/2000. So this principle is merely issuing appointment letters. People come, join, start working. After some time, they are placed before the governing body. This is consistently everywhere. So this will also not throw any light in respect of Dilip Haloi.
Serial number 13 also Lordship.
Same, most of them.
13
This
also.
college has that habit.
Lordship.
even after your lordships of the division bench order, that NUSAID is still to get the financial benefit. Litigation started in 2011. And in this case, in this Borkhetri College, the cabinet minister of Assam Education, Dr. Bhumika Burman, was asked to be personally present in this court in 2017. After that also, no, it can't be resolved.
But how do you decide this? Do you tell us? You tell us. Because you are the custodian of records and everything.
My lord, also kindly page 34 Lordship. Some of they have appointed in 92, but resolution 2007 resolution is also not there Lordship. In CL number 25 Lordship. And CL number 21 resolution is not there Lordship.
My lord, in fact, so far the petitioner is concerned, my lord, we have annexed the GB's resolution. But if your lordship looks into the affidavit of the respondent number 4 at page that.
No, Mr. Kumar, but difficulty is records are not there. What can you do? Records are not there. Had the records been there,
My lord, this appointment letter of R4 will be. called with the-
and this word Borkhetri College is not only the name of a college, it is also an expression which has a lot of meaning also.
Connotations.
Borkhetri College word itself has a lot of meaning.
But your lordship may also ask the respondent number 4, because he have annexed the photocopy. Maybe he has the original appointment letter with him also. I don't know. Because he has
Yes,
certified to
Mr.
be true copy.
They have the original of page 93.
That was seized by the police. Original was seized by the police and they have sent it.
Seized by the police.
Yes. They have sent, that is why I have the only photocopy. That's why I have stated.
Mr. Gogoi, get hold of a PP. No other way.
I will complete, my lord. Now, Apparently, these are the questions of fact. The jurisdictional authority on the direction of this honorable court look into everything. And thereupon decided that the seniority, whose senior, not only me and him, the whole court, because there was a lot of controversy about the employees of the college as I find going through. Obviously, it appears that there was some favoritism shown from time to time to show somebody as senior, somebody as junior, all that. Therefore, this honorable court ultimately found it is difficult on our part to look into it, but the authority should look at the actor. The actor has passed an order. The actor has passed an order looking into everything. Thereafter, again, complaint was made. And that complaint was again asked to be inquired into. And that complaint report was also submitted on that inquiry. That also clarified that this position is Satru now. He is junior to me by age. Therefore,
We understand your argument.
yes, that is now because of the criminal case, it was filed against Lukman Ali, alleging that my appointment letter was forced by him. Whereas the person who issued, who has lost the case, he himself has given certificates. He himself has given.
Okay, we understand. But
All these are there.
Upon hearing the learned senior counsel for the petitioner, the respondent number 4, and Mr. K. Gogoi, learned senior counsel for the higher education department, an issue had arisen that the page 93 appointment letter issued to the respondent number 4, page 92, issued by the principal secretary of Borkhetri College, is not an appointment letter issued by the principal. To this extent, there is an affidavit by the principal Mubarak Hussain that he had not issued the said appointment letter. But on the other hand, there is an admission by Mubarak Hussain that the appointment letter at page 17 was actually issued by him. Going by the statement of Mubarak Hussain, the signature of the principal appearing at page 17 appointment letter is admitted to be a genuine signature of Mubarak Hussain, whereas the signature appearing at page 92 appointment letter is not admitted by him to be his signature. It is stated that in pursuant to a criminal proceeding, the origin of the 2 appointment letters had been seized and is a part of the record of such criminal proceeding.
I can give
For the purpose which is stated to be for the as the issue had arisen as to whether the appointment letter at page 92 is a genuine document issued under the signature of the then president, then principal, which would have a bearing on the eventual issue to be decided as to who between the petitioner and respondent 4 is senior. We request the learned public prosecutor, Sri B. Sharma, to take up the matter with the authorities conducting the criminal proceeding to procure under seal cover the original of the page 17 appointment letter dated 19/11/2000 in favor of Muhammad Azad and the page 92 appointment letter dated also dated 9/11/2000 issued in favor of respondent for Dilip Kumar Haloi and submit the same before the court. A copy of this order be provided to Mr. B. Sharma for it being for facilitating the production of the 2 documents.
Your Lordship may indicate the case number also, Mukalmua PS case
Yes,
number
yes, case number
374.
We are proceeding pursuant to Mukalma.
Mukalmua PS case number 374 2011
Based on the
under section 467 469.
Sharma, how long will you take? Can you get it within 3-4 days or you'll need more? Monday. We'll just get it verified ourselves. Otherwise, this appears to be a little murky. We don't know what is happening.
Your Lordship can look,
And
your Lordship can look into the original FSL report also.
that again will be part of another. Why bring the entire
Yes,
record?
Yes,
Let us have
prima facie satisfied.
let us have the 2 documents involved in this proceeding. We'll get it verified. We'll send it back for the other proceeding.
It's coming up on Monday next.
Monday we'll send it for this thing,
Yes,
so that immediately after the vacation, we can have the reports and then take a call which way it is to be taken.
Let the documents come first. I want that my document has also been written by them, original. I couldn't get it.
Well, let's see what the PP says. Yes, why not?
Item 15.
This allegation is misappropriation, so your lordship please to direct them whether there's documents, whether this completion of the work has been submitted by petitioner or not. We have saying taking the stand that completion order was not submitted. So that is the allegation. Otherwise, fund cannot be handled by this petitioner because misappropriation.
Where is the completion certificate?
Mr. B. Gugoi is appearing for it.
Gugoi, where is Mr. Gugoi? He's coming. Completion certificate.
That record, if lordship will allow, my lord, I would like to place the entire record of the proceeding where my lord, all the documents will be there.
No. We'll definitely go through it,
My lord.
but you rely on a completion certificate?
Yes.
His case is outright denial. I have not issued it.
No.
So we want the completion certificate. We'll send it whether he had issued or he had not issued.
Lordship.
That will
yes.
clinch the issue.
My lord. That I can place on Friday, my lord. Only that.
You don't have it now.
Now I don't have it, my lord. Actually,
The original of the completion certificate relied upon against the petitioner, which again the petitioner makes an outright denial that he had issued, be produced before the court on the next returnable date, Friday, Monday.
Monday. I will make.
And the origin of the be handed over to the registry.
Item 16 for motion.
This
Yes. Here we have challenged the inquiry report by SLC Mother. The inquiry report is at page 87, Mother.
TGL.
Yes.
Petitioner to state the name of his father stroke forefather who was a tea garden laborer in which tea garden and in which period. We'll examine it.
My lord, in fact, my lord, there is an expert certificate. Prima facie, my lord, it appears, my lord, he doesn't belong to that category. That record,
No, let us go to the core aspect.
no, that is the, my lord, core aspect. The certificate has been issued by the tea state. They say that, my lord, the father of the petitioner was a supplier. He is not a laborer. He was a supplier of goods.
No, that's why you are relying. Let him
No,
produce.
his certificate and next to that.
Forget about certificate. Let him say, next was my father or grandfather. What is so and so tea estate for this period? We'll get it verified.
And I will do that. One more submission, madam. 112, madam, that page, madam. That the order pursuant to which they have carried out the inquiry, madam. That is, my lord, is a subject matter in the writ appeal. And the writ appeal, my lord, on 29/9, my lord, there was a kept in advance of the writ petition as well as the list which was published on the basis of inquiry 26, my lord. List they once they published second list on 28/9, and that list was there.
No, that is the problem of the appellate court. It is their headache, not our headache. As you have come before the court, saying we want the core facts. That's all. We have passed the order.
And another submission, my lord, that so far from the list, even if it is assumed, my lord, that the SLC report is correct, but the SLC report, my lord, is stated that only 25 candidates are, my lord, they are found genuine. But other candidates, my lord, that I have given in serial number 8, 12, 30, 23, 37, 38, 39. My lord, this person, SLC say, this they do not belong to that community, but they have been given admission. Therefore, I have made them party, my lord.
Very well, we will issue notice. If you have made party, we will issue notice. What's the difficulty?
And may I pray, my lord?
First you prove your case.
Yes, man, I do. May I pray, my lord, just after the notice, my lord?
No notice, we have just asked you the primary information.
Yes.
We order to deal on. When do you want to be listed? Next item.
So it may be done.
Take the shortest tomorrow. If you want.
Because my lord, once he was admitted and thereafter rejected.
What to do?
17 for orders.
Community, no one is stopping you. If you do not, it's a constitutional fraud. It should not be. That's
My
all.
lord, yes, that's correct. But others can.
Because,
Therefore, I made the party, my lord, with the.
Maybe
So for
because
others, can the private respondent.
for one fraudulent man, one genuine person will be deprived somewhere. We have to take note of that.
My lord, so for the respondents 8 to, my lord, this private respondents concerned.
I
will
think,
take
Mr.
steps.
Gogoi, the original order is not assailed anywhere.
Original, my lord, only the, my lord, order by which that inquiry was directed to be held, that has been, my lord, put to challenge.
That has been.
Put to challenge in the division. 1999 order.
Ha.
But the order by which my lord Lordship accepted the inquiry report and directed the Director of Medical Education to go ahead with the.
That is
has
not
been
there.
put to challenge.
That is okay then.
So we have done it, my lord.
Huh.
Only 4 persons got the.
And
my lord,
and the original order, it's regarding that who is a TGL. That one is under
yes,
challenge.
1999.
That is stayed.
That
Yes.
the order, no order has been stayed. Only the proceeding of that particular repetition has been
kept in
for
abeyance.
a timing. it has
Of
been
that
kept in
one
abeyance.
particular candidate,
Only one.
not a general.
No.
All the
Because
things-
has the determination of the law been stayed?
No.
Then it's okay. Huh.
Tomorrow, Lordship will, the division bench will look into the entire issue. We have been directed to file a.
But fundamentally, we don't know if you claim you belong to a community and the community has a distinct identity, you'll have to show that you have that identity. That's the only question. There cannot be interpretations, sub-interpretations.
My lord, primarily that Kumari Madhuri Patil was not followed by the SLC on that point, my lord, that has been stayed.
That is a procedural aspect.
Yes.
But the core aspect, Mr. Das,
I understand.
if a benefit is given to the tea garden community, there is a reason, constitutional reason to give that benefit. So there cannot be any technicalities of law that a person who does not belong to the community, by interpretation of something, he'll be given to believe that he belongs. And the core requirement is one of the forefather must be a laborer. So you tell the name of the forefather who is a laborer, will examine. If it is yes, you'll pass through. We are not against anybody, nor we are in favor of anybody.
But the inquiry was conducted through the DC, my lord. Deputy Commission Dibrugarh in a particular candidate has stated he does not belong to that TCL, but they have given admission to him also.
Mr. Das, therefore, we are not relying on any deputy commissioner, any these there. Four facts. Who is your father? Or father? That's all. Yes, next item, item 17.
My lord,
Your matter.
question number 8 to 39, my lord, that raised that post may be directed.
No, we are not yet issued notice. We are yet to issue notice. We want only the information.
My lord, otherwise, my lord, the information before page 84. My lord. Is that the information?
We are in item number 17 by now. What makes you hesitant to provide the information? Provide it. Provide the information. See, who is my grandfather? I know. Who is my great grandfather? I know. What he did also, I know. You also say. Item 17, yes, Mr. S. Chaudhary.
My lord, Guwahati University has already.
Mr. Das, when can you bring the information? Tomorrow?
Yes.
Whenever you want, you take that date. Day you can bring the information, you take that date.
No, day after tomorrow.
My lord, Guwahati University has already concluded the hearing. Report is also ready. My lord,
What matter was this?
My lord, regarding BA degree.
I think we passed some long order. What is this?
Earlier, my lord, on 31/8/2023.
Having a valid BA degree is one of the essential requirements.
Guwahati University has been directed to conduct for a hearing.
A report is also ready.
Okay, whether the BEd is valid or not, university will take the final decision.
Hearing concluded.
And you want some time?
Milord, will file an affidavit, Milord, pressing the
How much time we want?
2-3 days, Milord. Day after tomorrow it may come.
No, you take your call, whichever day. See, time is very less before the vacation. Next Tuesday. Next Tuesday. দীঘল order দিব পাৰিম। দীঘল order কৰিব পৰা যাব একেদিনাই চাই। Let it be after the vacation. Immediately on the reopening, you also take your time. Adjourn on the prayer of Mr. P.J. Fukan and counsel for the Guwahati University for the report on the question on the validity of the BEd degree of the petitioner as required by the order of 31/8/2023. This on immediately on the reopening will place it.
9th November.
9th.
6th year opening, 9th.
One thing is this matter, whatever the outcome, I may be confident to you.
You say that on 9th we'll hear you.
Before that, they may provide me a copy.
Milord, I'll file affidavit, Milord.
Okay,
Yes, I'll have to.
Yes. We'll
I
hear
think
you on 9th
18.
after the report comes.
I need further 2 weeks time to file my affidavit. Or we have responded of 5
Further 2 weeks time granted to respondent file to affidavit on the prayer of Mr. Sadrika list on so and so.
And Madam, the petitioner is to take step.
Sorry.
The petitioner is to take step also not in respect of resolution number 4.
4. Petitioner to take steps on respect for registered post.
Registered post. Yes.
Dusty?
Yes.
Dusty also.
As well as Dusty.
As well as Dusty to the registered, therefore file affidavit.
Interim order is there.
Interim order. Next date.
Deeply only.
Time being item 7.
কি হল 5 কি করলে affidavit.
Here, my lord, we have filed the affidavit today, my lord. Already it's not been checked.
It's stated by Ms. Neogil and counsel for the respondents in the secondary that the affidavit has been filed in course of the day. Registry will list again along with the said affidavit.
What that name is given, madam. They have taken a stand that my MA.
Mr. Sharma, master.
Next week.
Court master is the master of dates.
Next week.
Wherever it is available, you take it.
Item 9.
See where it is available, you take it. Huh? That seniority, this and that.
I contacted the ASP lot. They said that the original applications.
Sorry.
Original applications of the petitioner as well as the respondents. Retrieving that will take some time because the selection process was initiated in 2013 itself.
The respondent will produce the information of how many posts of LDA were available out of 185. That you must be knowing. The respondent produced the initial appointment of the petitioner as to in which district he was appointed. You must be having it on your record. Respondents to produce the original application so as to what choice of district was given. Because one issue had raised by somebody that one of the person, he had given a choice of different district. So we want to find out that, produce it.
Immediately on reopening, Lordship, if possible, because.
But it's
they
going on
say
for
that-
quite some time now.
Yes, Lordship.
Why didn't you produce it today?
Lordship, I have sought for it, but Lordship, they said that it will take some time because some third party was given the thing to do that, conduct that selection process, that advertisement, and after that, Lord.
Mr. Sharma stated that the entire records would be examined by the learned council. I think you are the learned council. Did you examine?
Hearing, I examined, Lordship.
You examined.
These records pertain to.
And thereafter makes a submission in view of the conflicting statements being made that there is a judgment of the Supreme Court way 11, the guidelines for selection and the private response. There is also a set of rule providing, and unsure which of the two were adopted. Which rule did you adopt?
Lordship, that also concrete instruction as of date.
Then how do you expect us to decide?
Lordship, that's why I'm
See,
seeking some time.
Mr. Sharma, if it is a claim of one man, we cannot decide anything. We can say give it to him because your records do not reveal. But here is a claim of seniority. Both are there. We'll have to decide either this way or that way.
Only some time, Lordship. I'll produce.
But I think enough of time had been granted. I myself has been hearing this matter from March, it appears, continuously. So if 6 months you can't produce records, what did you do?
Sorry, Lordship, but then
You need not be sorry. Then we have to issue a contempt notice against somebody that you are inhibiting the administration of justice by not producing it. You don't have to do anything. We want only the records. We'll verify it. You don't have to make submission also.
some time. Lordship.
Why?
Because it's of 2013, Lordship, they say. And
Who had done this agreement? High Court? High Court or the District
it
Court?
was through a third party Lordship. It was High Court only through a third party Lordship.
So third party, after completing the work, they don't deposit the records.
Yes, they have to deposit. They must have Lordship.
What must have?
But Lordship,
See,
those are 2013, since it's of.
that doesn't matter. So are you to conclude that 2013 matter need not be decided, petition closed?
No, no, Lordship.
Can we pass that order?
Only some time for that Lordship, since it's old.
How long? How much time? See the number of dates you have given. You are not bothered.
I apologize, Lordship, but then
But apology is not leading the court to decide the matter. Tell us something by which you can decide the matter.
pray that it may be taken up immediately on reopening, Lordship.
Why immediately? Why not before?
Lordship, I'll
At
try-
least the records you want to see. We'll decide later on. No difficulty.
I'll try, Lordship. Try to-
Nahi your report too. No, who is to produce the record?
Register recruitment, Lordship. Recruitment.
Please ask the register recruitment to come. Hmm. No, but after conducting the examination, they'll return the records. They are only an agency to conduct it. Can we have the register recruitment?
I'll inform Lordship.
Just ask the register to come. We want to know why its records are not available. Otherwise, how will you decide this?
I'm trying.
Just see. Because 12.9, some information received, it is inadequate. 22.8, same thing. Please ask, let us see. Please ask it. It last night, Arnai. Ali, itu naik your itu let us send everything. Okay. Nah, like. When will you fix next?
After vacation, madam.
After vacation.
1 week of the year.
As prayed for, list on so and so for production of the report as indicated in the order 26/9/2023. Ask the register to come. We'll just want to verify what is happening. Otherwise, how do you expect us to determine this?
No, but we'll have to provide. all.
They are saying, claiming something. We either have to say yes or no to whatever they say. How do you decide it?
That should be paying.
And even if the selection is conducted through some outsourced agency does not select. Outsourced agency will only hold the test. That is outsourced. And after holding the test, they'll hand over the records to the authorities.
That is how.
They have not given or what?
No, Lordship. Today morning, Lordship, they say that it relates to 2013, so they could not get all those things, Lordship. So it was not complete. Probably some of the applications were found, Lordship, but then the complete application